Let's just, what I should do is, Rabih, first of all, thank you very much for being part of the symposium.
Thank you.
And what I should do is, I should just put up what we're really doing. Just put that up, and then, because we're doing mediation legislation, but just a little bit of the poster up there just to show that, yes, this is what it's all about. So let's put that up. Because sometimes what happens is that if you see my shows, they all start so abruptly. Suddenly, although of course the description in the, YouTube will show what it's about, but it's just, I just start and let's go. Let's start having a conversation.
Great.
So okay, yeah, but this is what we're doing. Just to put it up there. So Rabih is of course here, and we're doing mediation legislation, the how, what, where, when, which, who, every question part of that.
Great.
Okay, so Rabih, you'll have to tell us about yourself, and after that you'll have to give me 30 seconds to put up my website and where people can find information. So please.
Great. So first of all, as a start, I would like to thank you for the effort that you are doing in mediation awareness and for giving ADR professionals the chance to get acquainted with the international mediation legislation. But most of all, I would like to thank you for giving me this opportunity to speak about Lebanese mediation and the Lebanese mediation legislation. So to introduce myself, I'm Rabih Sfeir, I'm Lebanese, and I'm an attorney at law for more than 15 years. And I'm a mediator. Today, I will not be speaking as an attorney at law, but as a mediator. And hope that this symposium will be insightful for all the attendees to know what is the current situation of mediation in Lebanon.
Perfect. So thank you very much, Rabih. Why I put up this website, I like to put it up there, is because I just find it more convenient if people start looking at find information in one place. Because I know that, look, all these social media posts, there's no way that you can keep track of the ones that I put. 50 sessions here, 50 posts out there.
Well, this is why today I will not be sharing any presentation on the screen. My intervention will be like a storytelling. I will be telling the story of mediation in Lebanon.
Perfect. Okay, so basically, but what you should go down to the website just to find out, because there are more than 550 videos on the YouTube channel. Now, how do you find out what it's all about? So at least what I've tried to do is, of course, World Mediation Circle, you must read about. But what I've done is year-wise, this year, so you can just click here and you'll see what all is happening this year, what has already happened, what has happened in 2022, 2021, of course, with Ken Cloak, all the sessions with him. So, and the YouTube channel, something comes. So lots of, there's so many videos out there. To find information is a little difficult. Mediation and Singapore Convention, I've got a section there, which of course I've put out what I feel is a very nice broad definition of mediation. Just to start this symposium, I had to put something out there saying that, look, this is what mediation is, because we'll start getting into legislation. But what does mediation mean to us by itself? That is also a good starting point, because legislation follows sometimes, but sometimes legislation doesn't follow the general understanding of mediation. So it goes both ways. So Rabih, it's all yours. I'm sitting here, not on mute, but I'm a mute spectator. Call me in if you want to call me in, please.
Okay. So I will be telling you the story of mediation in Lebanon today. Thomas Pitak, a German mediator and a professor, once said, "It is the practice of mediation that it's not the practice of mediation that is new, but it's theory." And in order to understand the theory of mediation in Lebanon, we have to go back to its old practice, to its root, to the Lebanese tradition, and to its legislative history. So, prior to the Lebanese judicial system, whenever two individuals were in conflict or were involved in a conflict, they always used they used to seek the help of their clan or their chief or their group or some dignitaries or even their social or religious leaders to solve these quarrels that they used to have. So these personalities were mostly known for their impartiality, for their objectivity, for their unbiased attitude. And when they were helping these individuals to solve their conflict or their quarrels, they aimed first of all to restore the peace between individuals. So Lebanese history comprises so many examples of these ancient mediation practice, whether it was conducted by priests or by sheikh or by the village chief that we call here in Lebanon the Mukhtar, or simply by old wise people, whether they were men or even women. This mediative recourse was known by the common word of musalaha or al-salah, meaning conciliation. This old form of mediation was practiced for a very long time in Lebanon, and it was even considered as part of our Lebanese tradition and customs. This musalaha continued even after the establishment of the Lebanese judicial system. And actually, it went along with the Lebanese judicial system, even if it was in unofficial way. In 1933, the former Code of Civil Procedure legalized the process of musalaha, and the legislature created, alongside the court of first instance, a post or created the role of the conciliation judge. And it was known by Qadi al-Salah. Salah is actually, it means in Arabic, conciliation. So what was the mission of this Qadi al-Salah, or the judge of conciliation? This judge had the specific mandate to conciliate parties at a lawsuit before its settlement by the competent court. So if the Qadi al-Salah succeeded to conciliate the disputant, he used to document the conciliation or the conciliation terms in the judicial minutes of record. Once these records were ratified by the judge, then they were considered as a final enforceable ruling. If not, so if the Qadi al-Salah did not succeed to conciliate the disputant, the lawsuit would resume in its normal proceedings. In 1983, unfortunately, the new Lebanese Code of Civil Procedure abolished the role of Qadi al-Salah, and the legislature delegated this conciliation mission to the ruling judge examining the case. So, although the Qadi al-Salah was abolished and the mission of conciliation was given to the competent ruling judge, the tradition of practicing mediation persisted in Lebanon, and it persisted among Lebanese outside courts in various fields, whether it was commercial dispute, civil dispute, even sometimes in family dispute. And in some cases, they referred to this conciliation or this mediation practice in certain criminal lawsuits. Now we come to our era of the mediation legislation. So from this traditional mediation practice, we reached the legislative era of mediation. But before going deep into mediation legislation, I would like to tell you more about something about factors or reasons that motivated the adoption of mediation laws in Lebanon. The development and progress of society in Lebanon, along with the complexity of human relationship, drove Lebanese to consider that the judicial system is unfavorable and unsatisfactory. Individuals sought for faster and less costly alternative to resolve their conflict. On the other hand, they considered and they perceived as that arbitration and the arbitral award as imposing in sometimes and complex due to the arbitration rules and procedure. The second factor that motivated the adoption of the mediation laws in Lebanon is actually the European directive that was adopted in May 2008, regulating the judicial mediation as an alternative to conflict resolution ADR. In fact, this directive increased a bit an unofficial practice of mediation as an ADR among a small category of Lebanese professionals. These combined reasons or factors led the Lebanese legislature to adopt mediation in two of its forms, judicial and conventional. The judicial mediation law. In October 2018, the judicial mediation law was finally adopted. The first article of the said law defined mediation as follows. Mediation is the process that enables parties in conflict to seek at any time during court proceedings the help of a third impartial person to help them communicate and encourage them to negotiate so they can resolve their dispute and find a solution, a suitable solution for their conflict. Within the same article, the legislature defined the judicial mediation. Judicial mediation is the process by which the judge refers the disputant to a mediator upon their consent to help them communicate and assist them in finding a solution for the dispute. So for the legislature, judicial mediation is starts when the judge refers the disputant upon their approval to seek the help of the mediator. So the text of law stated that the mediator will be designated and chosen by the parties from a list of mediators affiliated to the Ministry of Justice. Unfortunately, due to the current political situation in Lebanon and to the socio-economical crisis that's taking place in Lebanon since 2019, the implementing decrees regulating the judicial mediation haven't been issued till date. Before giving you an overview of the conventional mediation, there is an event that actually motivated and encouraged the Lebanese legislature to adopt the conventional mediation. And it is the Singapore Convention. In 16 November 2021, the Lebanese parliament authorized the Lebanese government to join the Singapore Convention. And we all know the Singapore Convention creates an attuned framework for the recognition and enforcement of settlement agreement resulting from mediation. So joining the Singapore Convention was a direct motive for the Lebanese legislature to adopt a new law regulating the conventional mediation. Actually, 1 year ago, almost 1 year ago, on the 14th of April 2022, the conventional mediation law was published in the Lebanese official gazette. Conventional mediation was defined as follows. It was a contractual amicable process to resolve conflict. And as such, mediation gives the right to any party to an actual or future conflict to appoint mutually a professional, independent, impartial, and neutral mediator to help them communicate and find a solution for their conflict. Conventional law, as well as judicial law, both texts determine the rule and regulation of the process of mediation, whether the conduct, the process, the termination, the expenses. All these topics were detailed in both legislative texts. And as well, they specified the parties' obligations and the mediator's duties. And here I would like to point something. The judicial mediation text had annexed to it a code of conduct that specified all the rules of conduct to every mediation. So it was part and parcel of the legislative text itself. As a conclusion, this is the story of mediation in Lebanon. Mediation is true, the practice of mediation is not new, but the theory and the legislative text are basically very new. Tradition and culture played a major role in writing the history of Lebanese mediation. As a mediator myself, I think that mediation will definitely have an impact in the future. But meanwhile, there is a necessity or a lot to be done in mediation. It is true that mediation laws were adopted, but the undeniable necessity remains in the essential work of awareness. There is a big necessity to spread an awareness campaign and set a well-designed program, most of all, to develop professional mediators in Lebanon. Unfortunately, many lawyers consider that a mediator will be competing with their litigation or their career, which is not basically true. Mediation is, if we can describe it, it's an added value, or it's a plus for them as a lawyer. In addition to this awareness, I think that this awareness should encompass the readiness of Lebanese to consider mediation as an alternative to conflict resolution and to apply it as a new technique to conflict resolution. And this awareness would be facilitated through webinars, through seminars, lectures, symposium like the one that we are having today. Local culture, local Lebanese culture embrace the concept of mediation. On this occasion, if you can permit me, Vikram, I would like to call upon all these concerned with conflict resolution, be it lawyers, judge, legal counselor, notary public, mayors, even municipal officials and advisors, even religious entities, to join forces in the promotion of the benefits of mediation. Because this is how we can, as a Lebanese society, we can promote the advantages of mediation, especially that the Lebanese society was shattered by so many conflicts, and mediation can facilitate the future for a better future in Lebanon. Thank you, Vikram.
Thank you, Ravi. That's a very nice, good thoughts that you have put at the end. Look, the thing for me, the first symposium was mediation in our culture and traditions. The whole idea was to highlight, like you said, that traditionally this has been happening in communities all over the world. So that was the first symposium. And of course, there were 97 speakers from 45 countries in that. So we got a good kind of understanding what was happening. But the thing was, why, of course, various other things came up, like you said, neutral. Now, I don't know whether your legislation mentions the word neutral, but my issue has been that should that word be used? Because then I had a symposium on neutrality and mediation. Because the thing is that by itself has a certain meaning, and whether a mediator is neutral, supposed to be neutral, can be debated. So I've again, when it comes to legislation, I've always feel that why put words which have a meaning, which can be looked at in various ways, and then is that what the process requires? Does it require a person who's neutral? So those are the kind of things we have to discuss, that what words to put in, because for the user, now, how do you really need to sit with the user and explain what neutrality is? That by itself is a whole debate.
Unfortunately, this is what happens here in Lebanon, whether when we are conducting a mediation session, we have to explain this terminology because they are not very common for any person that uh, is being part of as a mediation session. So we have to explain this terminology that basically is actually it is a very specific, sometimes it's very legal terminology that they are not familiar with them. So and to and I would agree with you that maybe sometimes the legislation should be more how to put it,
worded in a manner which is simple, worded in a manner which the people understand without having to explain the
yeah,
legislation to them.
exactly. They have simple wordings, simple terminology in order to facilitate the understanding of mediation and the process of mediation. Because most of the time, it is our task that we explain these words, these terminology to every person coming to seek his conflict resolution through mediation.
Yeah, that's exactly what I've been saying, that the legislation should be simple enough for the user to understand. The user should not require a lawyer to explain the legislation to, because finally it's the process, it's the people's process which has to be, of course. Look, I was telling about the symposium. The other symposium that I did was on indigenous peoples and mediation. Again, to understand, but a little more in depth into that aspect of what has really been happening. Because I've always been saying that what we need to do is be very careful when we say that communities used to have mediation, because communities also had arbitration. And that word is important. Like you said, sulh, you're using the word sulh. Now people will understand what sulh is, and they will connect to the process because of that. So that's the word we need to pick up. Like in our, if you saw my post, I spoke about the Indian legislation, which is called conciliation, of course, taken from the UNCITRAL conciliation rules. But when it's translated into Hindi, it is translated as sulh. So our law in Hindi is called sulh, which is, of course, we have these, with all that interaction with the Arab world and India and all, so we have those common words. So if I keep telling people that, look, if this whole debate, mediation, conciliation, potato discussion keeps happening, why don't you just look at the Hindi version? Hindi version says sulh. People understand what that word is. It is something that they connect to. It's a process they will connect to. Why not use that? Why confuse people and get into these academic discussions on mediation, conciliation? We don't have a law on mediation, like that kind of thing. So that's what I have to.
I think it's the best thing that we as Mediator we should do is to work on explaining this terminology and working on this awareness in order to facilitate the understanding of the legislation text. And this is very mandatory.
So that is why I'm saying that this symposium, one of the idea is that let us discuss this terminology. How simple can it be? What we should, what we should not use. Look, even impartiality today is debated, whether it is omnipartiality or is it impartiality or multi-partiality. So each of these words will keep getting debated. Now, of course, you want to use some word there. I say trusted by the people, trusted by the participants. I'm happy. With trust comes everything. If the person is impartial, that trust will tell them what it is. But of course, maybe legislation will have to see whether how that fits in. But the point is that there are certain things which the process requires, where can you be that, in that sense you need to be omnipartial. That whole debate discussion has to happen. But that, let me put up the theme of that, because this is important, the aspect of that word. This was what that symposium was. Rafael, Mexico, called it the Woodstock of mediation. He made this poster that time also, but this was what the theme was. Has been defined in the convention, has been part of our cultural traditions, part of our cultural heritage. This is the important part. I'm saying people around the world may not be familiar with the word mediation, but they're familiar with the process. as it has been used from
True.
time immemorial. So collaborative approach to dispute resolution has been used by families and communities, including indigenous and business communities, for centuries, and has passed on from generation to generation. So we have to go back to our roots and move away from an adversarial approach to dispute resolution to a collaborative approach. So this is how I felt that, again, now legislation, of course, in English will use the word mediation, but when it comes to Arabic, will Sulh be all right if they use Sulh? Call it.
Well, listen, in Lebanon, it would be difficult for people to use the word of sulh, because sulh and mediation, they have a slight difference. In sulh, it is the person who is proceeding in the sulh, he will give the solution, whereas in mediation, the mediation that we call wisata in Lebanon, it is not the mediator that gives the solution. It's the party themselves that choose the solution. So maybe if we emphasize on this difference between the sulh and the wisata, but maybe they have the same root at the end, at the beginning. So trying to create a peaceful society, trying to bridge between both parties and creating a peaceful environment. So both they do have the same goal, if we want to name it as such. But there's this slight difference between sulh and mediation.
Well, that's a very important difference that you're making, because if it is understood as a process where the solution is something that what the conciliator or the person who's doing the sulh, what the solution that the person gives, and that is what has to be acceptable to the people, then obviously we should not use the word. But if the process is that the person who's doing the sulh suggests the solution, they may or may not take it. So we have to be clear.
You know, sometimes mediators are facilitators, and sometimes they do propose indirectly a solution, but at the end it's the parties that will decide either they take it or not, as you mentioned.
Yeah, that is okay. That is okay. Look, then because look, that option, you will have to keep that option, because this aspect of it being totally a facilitative process where the mediator should not even suggest something is also what some parts of the world believe that is mediation, and suggesting is not allowed. We will not suggest. So that's what I said. The mediation itself is understood differently. So when we talk about mediation legislation, we go straight to legislation, not considering what do you understand by mediation. Because for me, look, how I look at it is that the legislation has to be broad enough for a situation where someone suggests, because it can be part of the process that someone suggests something. Now, does that mean that the whole process has got vitiated only because the suggestion was made? But that will be a problem when you go tomorrow, if there is a settlement agreement and you go, someone challenges it and says, oh, this was suggested by the mediator, so it is not, I mean, I am not bound by it, something like that. So we have to, for me, that's why I put out the Indian legislation, because there also it says may suggest. It is not something that has to be done, but it is not an issue if it is done. So
exactly.
So I think we need to keep that option open, because look, this whole thing that we will only make it a facilitative process might be all right, and some people in that country might believe that, but some people in the country might believe that they want the person to suggest. It all depends on the way they look at the process, what they expect from their mediator. So we should not limit it so much that it becomes a constraint on the process itself. So that is, this is an important aspect that you're saying, that how people understand the process. And as long as it is not something that they understand as, yes, solution has to come from the mediator, and whatever solution comes, we'll take it, then it becomes arbitration. Where is the mediation in that?
True. And you know, many times I had to explain and to explain the differences between conciliation and mediation for the parties that were having the mediation session to clear this concept properly and to tell them that I will not be giving them the solution. It's up to them to find the suitable solution for their conflict. Sometimes maybe you can indirectly highlight an idea for them when you see both parties are stuck somewhere, but they are basically on the same level. So this small sparkle might facilitate for them the route to find the solution, but you don't give them the solution. You give them maybe a sparkle to find the solution.
Look, for me, I tell you, for me, how it is. You are with people, and all of us are sitting together to solve the issue. That's what all of us are trying to do. Now, in that kind of a situation, if something comes to you and you hold back, I mean, even a conversation, you can suggest or you can discuss certain things. What are the options? You will do that. What are the options? But these things will normally happen. So when a person puts that kind of a dividing line, oh, I don't have to cross this line, I have to stay here, then you won't be yourself. So I say you be yourself. Finally, it is the people, the participants in that particular mediation, they will see whether they want that from you or not. It's their choice. I mean, we should not, I mean, they'll tell you, Rabih, please, we don't want your suggestion. They can tell you that it's a flexible process. It's their process. So I just feel that I think a little too much has been dealt with on this aspect, because look, the issue also is that there are certain training institutions which come with the maybe the ideology and philosophy that mediation is only facilitative, like I told you. And that aspect, when they take that, they go out, and which of course, training for me, you don't, I know, I mean, that is another discussion I have, that you don't train someone to become a mediator. That's another debate, but those trainings are happening. So in that training, then they create that little, I mean, that line, okay, this is your line.
Yes.
That I think for people, I think might be a limiting factor also, because it all depends on who those people they're sitting with, what they, I mean, it's their relationship with the mediator. I look, finally, it's all about someone not imposing a solution on you. That is what the important part is. That is where the Singapore Convention comes in. Also, that definition, not impose, but to suggest a solution. I don't think there should be any restraint in that. I don't know what you would feel.
Indirect suggestion.
I am saying I am very direct on this. I am okay with suggestion. Look, it's my friend. You're my friend. I'm sitting with you, and if I hold back something that comes in my mind and something that can help you, I'm not being fair to that relationship, because that's what the relationship is. That's where the trust comes in. Trust is to the fact that you are doing the best for them. That's what you're there for. And if I am seeing someone doing something which I feel would, maybe it's not in their best interest, we're discussing something, if I don't put it out to them, as long as, look, like I said, if I'm not going to force you, I can't force you. That has to be clear. That is to be clear from the starting point. This is your solution. This is, you have to.
It's a voluntary process, and this is very important to highlight on this voluntarity of the process of mediation.
So now what we have to do, Rabih, is now we have to, from our side, think of what should legislation look like. Domestic legislation, globally, if the Singapore Convention, we have something there. Then we have a model law that, of course, UNCITRAL has put out. So looking at all that, what would you think should legislation look like in Lebanon itself? Why, I'll give you a little pointer as to where I'm going. How I'm looking at it is that being a process which, of course, it's not restricted into where you're going to do it, first of all. So you could do it anywhere in the world. There might be a dispute in Lebanon, but you can have someone somewhere else in the world who might bring in, be it physically, you might go to that person might come to you, or you can go online. So,
eventually, what I think is that mediation is it's science, maybe, if we can use the word of science. It's teaching. It's most of all, it's human. So if we want to go from this criteria of mediation is a human process, then it should be simple and how to use it. Every person should understand the process of mediation. This is why I think legislation should not be like a mold of rules and regulation. It should be flexible, without so many texts, maybe defining the process of mediation as a process, and then maybe giving them techniques of conducting the process of mediation, but not using the word or terminology of rules, because mediation should remain flexible and human and transformative. And once we consider mediation text, mediation legislative text as rules and regulation, we will lose the concept of humanity in mediation. And for me, it is very important that text should remain flexible, human, and that they are, how to say it, in reach for every human being, whether he is cultured, uncultured, educated, not educated. So I think that the text should not be very long, several pages long, or with so many articles regulating the process of mediation. Maybe just defining the process itself with few principles, and maybe highlighting the principles that, as we mentioned earlier, impartiality, neutrality, and maybe with an addendum to the text, but not the core, the legislative text itself. So this is my vision of legislation and mediation legislation.
But did you have a look at the Indian law?
Not in full.
Okay.
Not in full.
So I mean, like I said, it's come from the UNCITRAL conciliation rules 1980s, and they put it out. It's simple, very simple, nothing complicated about it. It is, I mean, the way, look, the only thing is that how much about the process should you write, how much of it should, I mean, it becomes a little too much. That part of it also needs to be discussed. So that's why on the 19th, when we said, the whole thing was that let's discuss how much to write. That's why we have a model law available. Of course, the old one was always there, but they've now got this, I mean, the new model law. We'll have a look at that, because I mean, I don't know whether let's just quickly go through it. Let's see what your thoughts are. Right? The simple. What would it apply to? Not a problem.
Excuse me, sorry.
This is what that, I mean, this is from my Indian law. So
okay,
have a look at it. I'm just taking you through it because for me, this is nice and simple, and I'm going to take your thoughts on it. Neutral word, I not want the word neutral written there because that's a debatable terminology anyway. So this is simple, that out of legal relationship, whether contractual or not, okay, whether then we
it's very simple.
Yeah, then
it's very simple.
On the commencement part of it, that you write, you send a invitation to conciliate to the other person, and if the person can reject it, if the person, they don't receive information from them, then it's treated as doesn't go forward. Then otherwise I can tell you. So okay, simple process, however it's worded as to how it's going to happen. Here they said, okay, there can be 1 or 3. In this case they said 3. Now whether that should be there or not, I don't know. Then as a general rule, should act jointly. That by itself should be discussed, whether should you have to do it jointly, or can you have different meetings with different, if you have more than one.
Here in Lebanon, some centers would consider it's more preferable to have co-mediation.
Yeah.
Whereas others would consider, no, it's more accurate to have one mediator giving the session. So it's a culture maybe. And maybe sometimes if we have, let's say, in a family dispute between a man and a woman, to avoid any unbiased attitude or consideration, there would be two mediators, one a woman and the other one a man. So this way they will create a kind of an equilibrium of the mediation session.
So that's what I'm saying. Here the option is given that it can be one or it can be co-mediation. But and the thing is that okay, they've put a limitation to 3. Whether that limitation should be there or not can be discussed. But the main thing, like I said, was that it says should act jointly. Now, whether that part of it should be there or not there, it is up to them. For me, look, it's a flexible process. You can have a meeting with one of them also. So that needs to be, of course, looked at. Of course, I mean, this is how they have to be appointed. May agree on the same when they're two, how it has to happen. Basically, a process of how to appoint them. So that's okay. That needs that. That's required. This was interesting. Yeah, that.
So you're more, if I may understand, if I understand correctly, so the mediation, the Indian mediation law is more, is highlighting on the process of appointing mediator so far.
Also, yeah, up till now, yeah, it's basically going through each of the stages. So appointment of it, I'm just reading, this is, look, I'm looking at it from the UNCITRAL in 1980, putting them out, and shall take into account the advisability of appointing a conciliator of a nationality other than the nationalities of the party, being a domestic legislation, but it is still looking at situations when there might be people from different nationalities. So I'm just saying that the whole concept of it being looked at from a global perspective was always there. I mean, that in domestic legislation also. May request.
And if I may say, some of the Arab countries do have this, not a confusion, but a similarity between the concept of conciliation and mediation. And they consider it as one, especially because their practice of mediation or conciliation comes from this traditional elderly authority or their religious chief that were conducting the process of mediation. So there is this, maybe, I don't want to use the word of confusion, but kind of similarity between both techniques and both concepts. And and till now they did not have a clear text to define clearly the concept of mediation or to differentiate it from conciliation.
So let's say for a moment, let's leave these two words out, because like I said, there's too much debate on these two words. Let's look at a third word which has nothing to do with these two, so that there's no confusion. A third word which defines the process in a simple way, which is why I said the Singapore Convention is broad enough, but because there are situations which have been created, the voluntary word is not mentioned there, because in a lot of these processes, when the court system has come in, it is not voluntary. Maybe sometimes this whole concept of mandatory mediation, which of course is an oxymoron by itself. So maybe that word, whether voluntary word should have been there or not, that's one thing that has to be looked at. But otherwise, it's a nice broad definition. So the word mediation doesn't matter as long as the process can be defined in a manner. Yeah, as we can be defined in a manner where people can understand. Because thing is that if within the mediation world also there is such a debate on what is mediation, what is conciliation, the user is going to get confused. The user doesn't understand what is it, where the user is not even, according to me, concerned what that debate is. Are you here to help me or assist me in resolving my dispute? Yes. Are you going to take the decision, or I'm going to take the decision, you are going to take the decision? As simple as that. What else do you want to know? So let's ask the user, what do you want to know? What would you want in the legislation? I think that's what we need to do, rather than put in words which for them, to explain those words will become one session for Rabih. One session, let us just discuss the legislation first, then we'll move into the process. So I think
maybe, we have to focus on the result, not on the outside of the terminology of the process, but aiming further on the main goal of mediation, which is basically helping and assisting the parties to find themselves the proper solution for their conflict.
So basically, what ultimately it's how simple it has to be: a voluntary process, a person trusted by you to assist you in resolving your dispute, who does not have the authority to impose a solution on you. It can be as simple as that. That we need nothing more than
Sure,
that.
sure.
Impartiality, independent, all those things we throw those things there. If you trust the person, all these things you've taken care of. But okay, you want to throw in a few
Sure.
words, throw in a few words, I'm okay with that. But beyond that, what else does a user want? Because look, I have, of course, in all these sessions I've been discussing that confidentiality being protected, we want that. So that's one thing. The process should be without prejudice. We would want that, obviously. The other is that the mediator not being called in as a witness. Perfectly all right. That's these are the things we need. Beyond that, the settlement agreement should be enforceable like a court degree. This is what we want. That's it.
Sure. You know,
What else do we want?
it's clear and simple. You know, in our Lebanese process of mediation, the introductive session, during the introductive session of mediation, we explain all these terminology and all the process of mediation in order to make the parties to get acquainted with the right definition of mediation. And I think for us as Lebanese mediator, it is important to highlight on these, because mediation legislation is still new, considering other countries, or maybe in comparison with the process of conciliation that the way they were used to previously. So when we highlight the exact meaning of these terminology, they will get acquainted. But later on, when mediation will be applied frequently, we will not have to define these words. So because they will be familiar with the process.
I think that's what the point is, that here the legislation is also educating the user. That it's the job of the legislation has become that, whereas it should not have been required, because people should have obviously been known what the process is. Only thing is, because we moved into this whole adversarial system of dispute resolution and the court system, the colonizers court and all that came in. So you now had to explain to them that this is what the process is, which was something which we should not have been required.
Well, you know, I think that the process should take time, and we should give the mediation our time to explain it. But later on, things will go with the flow and will go easier, and there won't be like a kind of template for a mediation session. It will go with the flow of the people.
Yeah, because I think that's what happens, is that when you try to educate through a legislation, sometimes it also you feel that a little too much is written. I'll just show you the further section. One was, of course, before that, what I showed you. Before that, it was not bound by the CP, the Code of Civil Procedure of India, or the Evidence Act, which is important. And all these things should come in. But this was what I mean, to put it out there. You use this kind of thing that shall be guided by principles of objectivity, fairness, and justice. You don't really need to write all this. You did not need to, but you were, of course, wanting to tell the user what it's all about.
True.
Because that's why, otherwise, it should have been understood that all this is taken care of. Giving consideration to the rights and obligations, usages of the trade concern, all these things. I mean, this is something which was obviously part and parcel of what's happening, but you had to put it down there. Flexibility of the process. Now, this is which comes in where we were talking about may make proposals. This may was required, because if it was not there, this would have become an issue, because proposals will be made as part of a conversation. These things do come up. and need not be in writing, but in your conversation, you are obviously, I mean, it's just a thought that comes to you. Now, whether it's called a thought or a proposal, those are words that you can use, but a thought comes to you, you would put it across. So it doesn't go against the process in the
Of mediation.
legislation if it is been suggested, because that I feel that if you had not mentioned it, it just becomes an issue later that whether the person, because it becomes debatable, because everyone will have their different thoughts on the process, and someone says, no, that person gave a proposal, no, should not have. That I think should not have go. I mean,
You
this is
know,
good. I like this aspect. Okay, administrative.
this,
Yeah,
yeah, it should come naturally. So if we have to the possibility to propose something,
yeah,
let it be without
exactly,
making it an obligation.
exactly.
But in a way, in the technique of mediation, we can propose indirectly a solution, or maybe the first step of a solution for them.
Exactly. So that, look, this is something. What happens is there's some vested interests, obviously, in our country, and I'm sure almost parts of the world, who really don't want mediation to take off. So what they do is that, first of all, they have this very, I mean, this debate on whether conciliation, mediation, and I have to, of course, explain that. Then they don't want to read this particular thing, and they say, oh, in that it says that the conciliator will give a proposal. I said, please, all you have to do is open the act, just open it. What does it say? It says may. Why do you keep confusing people that this is a process where that person is the one who's going to, in a way, give the solution, and yeah, they have to accept it. They try to create those pictures around the legislation. Okay,
You
administrative.
know, sometimes they read, but they don't want to see.
Exactly. That's what, look, it's a big issue. I'm telling you, it's a big issue,
True.
because what is happening is, okay, this we haven't discussed that, but we will discuss that what is happening in legislation is that these institutions and training institutes, their vested interest is some way coming into legislation. One, a certain certification, if you can get that going into the legislation, can you imagine what kind of a business you've been able to create if only a few institutions, their certification is what is, because finally someone will have to say what certification. So now you also opened up the door to corruption, because to say that, okay, these institutions are the ones that will give the certification, only then will you be a mediator in this country, you already opened that door. The other is those institutions who actually administer. I mean, they have these. I mean, they take care of the process, in the sense the logistics of it and all that. Obviously, they can't do the mediation. The mediator will have to do it. But those institutions in some countries have been able to get this, that before going to court, you have to do the mediation with those institutions. So can
True.
you imagine what you've done? What a business you've been able to create, that all this before litigation, if you have to go to these people. So that is coming up in legislation, which is for me a very serious thing, because we have a bill. Of course, we have the next speaker is from India. He's also he was part of that drafting of that bill. So in that bill, there is an attempt to regulate the institutional part of it. And then a pre-litigation is what they call it, which of course I have a little bit of that terminology I have an issue with, pre-litigation, because there was a concept of pre-institution, that before you going to file in the court, you have to do this. Pre-litigation sounds so broad that at what stage are you doing it? Anything before you actually file it, will all that process, you will call it pre-litigation? When will you call it? What is that point of time when you need that mediation to be done? With a little bit of clarity could have been done. But the main thing was, there was an attempt that should be controlled before you go to court. All that mediation that will take place, if it goes to a few institutions, can you imagine the size of this country and how much litigation is there? And that if it went to a few people, and so that part of it is a little thing we have to be careful about, who gets their say in the legislation. So what your thoughts on that are will be obviously important. What do you say on this
Well,
aspect of the vested interests coming into the picture?
so I think what you've said is true, but at a certain time, at a certain point, I think when mediation is still mediation legislation is new in a country, I think the best way to organize it properly, we have to abide by, at least mediators should abide by the text of law in order to facilitate and to expand its process. But later on, maybe we should facilitate the process of mediation and make it more common for people. So this way, the legislation would be for the mediators. So it's kind of some rules for them to work and to proceed in the process of mediation.
There's one person who's putting comments in that, which is, of course, Victor. Victor has actually been banned from my shows and events now because in his session, he didn't land up. No message, nothing. He doesn't land up. And then suddenly 5 minutes before his session was to end, he came down. So he's now been banned from shows and events, but he's putting some comments there, which of course, I don't know whether I want to answer. Or Victor, I don't know whether I want to answer your comments also. Maybe, maybe not. But anyway, we don't have much time left. But all he says is that I'm loving the conversation. That's good. But he had some thoughts there, but I was just waiting that JP is trying to connect. His audio is not connecting. It's connected now. Yeah, perfect. So actually what we do is a little wrapping up can happen. Rabih, your concluding thoughts, and then we'll get JP in. Yeah.
So as a wrap up, I would say that we hope that mediation legislation will go forward in Lebanon, and especially with the awareness programs. And we're counting, hopefully, that mediation would have a major role in conflict resolution in the future.
Yeah, but I think in terms of the legislation, a little more. I think maybe as on the 19th, that workshop that we have, we'll put in a little more thought as to what all should and should not, whatever direction. Because look, right now the stage is when the direction it'll go into a certain direction, and for me, that vested interest part of it, we have to be really careful on that part, because that can take the whole concept. Because from a people's process, it might become an institutional process, and people will then associate it with that whole technical institutional part of it. What we haven't discussed it whether it should be part of the court system or not, but that maybe we'll get JP in. So JP, you want to say hi to Rabih before he leaves?
Hello.
Yeah, hi. Sorry, I had muted myself. How are you?
How are you, JP?
Good.
Rabih is in Lebanon. We just kind of wrapped up his session, so I'll close his session and then we'll get you in. So Rabih, thank you very much. And of course, we'll see you on the 19th.
My pleasure. Have a nice afternoon, and thank you for everything.
Thank you. You can say